Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the recent decision from the Supreme Court of Canada about the federal carbon tax. The carbon tax was challenged as unconstitutional by the provinces of Alberta, Saskatchewan, and Ontario, saying that only the provinces have the power to enact a tax the way the federal government has. The law was struck down in Alberta, but it was upheld in Ontario and has now just been resolved by the Supreme Court. The federal carbon tax is here to stay, but don't call it a tax, at least not to the majority of the Supreme Court, who held that the legislation in question, the Greenhouse Gas Pollution Pricing Act, is a regulatory charge, not a tax. I actually participated as an intervener in the Ontario challenge to the federal carbon tax in 2019 while I was in a previous role. I think we might actually have a picture of me in court that day. I can tell you that the benches of the Court of Appeal were never more uncomfortable. Now, today we're going to be joined by 4 experts to talk about the carbon tax. First, we're going to be speaking to Aaron Woodrick from the Canadian Taxpayers Federation and Michael Bernstein from the Centre for Clean Prosperity about the carbon tax as policy. Then we'll be joined by legal experts Dwight Newman and Omar Ha-Radai to discuss what the Supreme Court decision means. Aaron, Michael, thank you so much, both of you, for joining me. Michael, I'd like to start with you. Can you explain to our viewers how this law, the Greenhouse Gas Pollution Pricing Act, works?
Sure. So there's 2 key elements of this law. The first is the fuel levy. That's the one that most people are familiar with. It's the one that imposes a charge on gasoline, on home heating, and several other goods. And then what it does is it takes all that money collected in carbon taxes and returns it to households in the form of rebates, in addition to providing some money for small businesses and for nonprofits. So that's the first part of the law. The second part is an industrial emitters system, which charges large polluters like, think about steel mills or cement factories. And a similar kind of concept there. It's a little more technical, but essentially, they get charged for their emissions and they receive a portion of that money back as a rebate.
And to be clear, this law applies when a province doesn't have its own system in place that meets the federal standard, correct?
That's exactly right. So the federal government says, look, this is the minimum threshold. Provinces, it's your choice. You can put in a system that complies with our minimum threshold. But if you don't do that, we're going to put in place this system for you. So today, you have this system applying, the backstop applying, that is, in 4 provinces, Ontario, Manitoba, Saskatchewan, and Alberta.
Okay, so Aaron, your organization has challenged the carbon tax as a policy, but also as an intervener in the challenge to the law. Can you explain your view to our viewers what you object to?
Sure. Well, our organization advocates for lower taxes. We are talking about a tax, notwithstanding how the court has defined this in narrow technical terms. So we oppose it on those grounds. It increased costs, and we think that's a burden on Canadian families and on the economy. In terms of the legal fight, we just view this as another avenue to challenge this law. So we were actually the only non-governmental intervener against the tax in all 3 lower courts and at the Supreme Court.
Michael, how do you respond to Aaron's criticisms that this is, essentially a tax, that it's making life more expensive to regular Canadians for essentials of life?
Look, I respect the fact that we want to have a low cost burden for households and we want to minimize taxes. I think Aaron and I probably agree with that. But the challenge here is that if you're going to do something about climate change, a carbon tax and rebate system is actually the lowest cost way to go about it. So this is actually, in my view, and I'm very keen to hear what Aaron thinks here, but if we're going to agree that we're doing something about climate change, the way to keep taxes the lowest is actually, ironically perhaps, but in fact the case, to apply a carbon tax as long as we send that money back to taxpayers.
Now, Aaron, I'd like to give you the opportunity to respond to that after the commercial break. I know that you guys have disputed this issue for a really long time, and I think that this conversation about the differences you have is so fascinating. We will be right back after this commercial break. Welcome back to Canadian Justice. I'm Christine Van Guyen, and we're talking about the recent Supreme Court decision about the federal carbon tax. Now, Aaron, I want you to respond to what Michael said in the last segment, that the carbon tax will actually be less expensive on consumers than alternatives to reduce Canada's greenhouse gas emissions.
Sure. I think what Michael's getting at is that given, if you compare it to the alternatives, this is a cheaper way to do it. And I would agree with that, but it is still a cost. And when we talk about the rebate, again, I certainly agree that giving a rebate is better than not giving a rebate in the sense that it's going to lower the cost for some people, and in some cases offset or more than offset. But I worry because if we look at provinces like British Columbia, who implemented a system which was revenue neutral at the time, we see over time that governments find it very difficult to resist the temptation to keep that revenue. And in fact, that is exactly what happened in British Columbia. So we essentially see this as, turning on one tap of revenue out of taxpayers' pockets and promising to turn off another one. But the problem is that other tap is still in the wall, and governments find it very hard to resist turning that other tap on down the road.
Yeah, it certainly requires a lot of faith that government is going to keep this so-called revenue neutral. Michael, I want to ask you, it looks like the carbon tax is here to stay now. How have the provinces who challenged the policy responded to the Supreme Court decision?
Yeah, I would say overall, it's been a very encouraging set of responses from the provinces. So the one who's provided the most detail so far is Premier Scott Moe in Saskatchewan. And he's indicated that he's going to put in place his own system, likely, although we don't have the details yet, reducing some fuel taxes to compensate for the extra costs from the carbon tax. Jason Kenney himself has said he's going to look at a variety of options, and his main criteria is going to be to keep costs low for households. And Doug Ford, interestingly, has not responded yet, but I actually take that to be a positive signal because he has been very, very vocal in the past about his opposition to the policy. So the fact that he's taken some time to consider his options, I hope is a constructive sign.
Aaron, what's your view on the responses from provincial leaders and what this means for sort of some of the conflicts between, the West, the Western Canadians and the federal government?
Yeah, it certainly puts the premiers on the spot. They have to make a decision. Do they stick with what Mr. Trudeau has imposed on them, or do they try and come up with something else that also imposes a cost, but that, in their view is going to impose less cost? And if you look at Scott Moe as the example that Michael mentioned, he's looking at New Brunswick and Prince Edward Island. And what I find interesting there is that those provinces introduced a system which don't strictly meet the lower threshold that the backstop sets. And yet Justin Trudeau and the federal government allowed them to proceed with those plans. So it's going to be interesting to see if they allow a province like Saskatchewan to also apply a similar approach, which technically puts them below the threshold, but that the Trudeau government accepts anyway.
Michael, what's your view on the future for policies like this? Is the carbon tax here to stay, or is it, perhaps subject to the whims of whoever is elected into office?
Well, I'm certainly hopeful it's here to stay. I think that the key missing piece here is what the Conservative Party, both the premiers as well as the federal party, choose to do. But the reality is, if we're going to do something about climate change, we know this is the most small c conservative way to go because it puts the power in the hands of the private sector rather than government, and it keeps costs low. So to me, I think there's a very strong likelihood that we will see this policy endure for the long term.
Now, Aaron, how do you push back against a law like this now that it's been upheld as constitutional? And what's next for the Canadian Taxpayers Federation?
Well, Christine, we've always taken a sort of two-pronged approach, right? We disagree with it on policy, and we disagree with it that it was constitutional. Obviously, one of those avenues has been closed. The Supreme Court has ruled on that, and we accept that. But just because you're allowed to do something doesn't mean you have to do it or that it's necessarily a good idea. And so we'll continue to make those arguments.
And Aaron, do you have a reaction to what the court held on calling it a tax or not a tax?
Look, yeah, you can call it whatever you want, a levy, a regulatory charge. It's interesting because, proponents like to call it a price, opponents call it a tax. I think to the average Canadian, it doesn't make much of a difference. If it's money that you don't have to spend, that you used to have to spend, you can call it whatever you want. I don't see people starting to call it an income price anytime soon, for example.
Yeah, I mean, certainly the effect is that people are paying this money, whether they are getting it back for now is is a different matter. And certainly it requires some faith in the government that they continue to keep this as a revenue neutral tool and don't see it as another revenue raising opportunity. I want to thank you both so much for joining today. It's been a really important conversation, and I'll be interested to see where this policy goes in the future. Thank you so much. Welcome back to Canadian Justice. I'm Christine Van Gyn, and we're talking about the recent Supreme Court decision upholding the carbon tax. Joining me now is our panel of legal experts who are here to break down the decision. Professor Dwight Newman from the University of Saskatchewan and Omer Hawardai from the Durham Legal Clinic. Professor Newman, this was a 600-paragraph decision. For our viewers who aren't going to have the time to read it, how would you summarize what the majority found here?
Well, I would recommend they all go read it. It's great fun. But in simple terms, the majority spends some time talking about the seriousness of climate change and does some writing about that, then ends up holding that it is open to the federal government to set minimum national standards on the pricing of carbon for the purposes of trying to address climate change. And to do so, they adapt and develop some aspects of the national concern branch test, the legal test that's involved. They come to some interesting conclusions that I don't know that we necessarily would have thought before on some technical things, like whether the federal government and provincial government can both regulate something that's found to be within that branch of the test. So there's lots there, but in simple terms, it's about those minimum national standards.
So, Omer, Professor Newman's talked about the national concern doctrine. Can you explain for our viewers who might not know what is national concern and when does it apply? Because the provinces here had argued that they can impose their own climate policies tailored to their own circumstances, but the court here said, no, this is national concern. The federal government can regulate here. Can you explain that concept to our viewers?
Yeah, I think more accurately, the court has said, look, the provinces can still regulate in this area, but if they don't regulate up until the point where they're helping Canada meet our carbon emission targets, then the federal government can introduce their measures to effectively regulate their activities. And so it's a little bit more convoluted than that. This is obviously a very new decision dealing with an unprecedented type of situation here. But I think the best way that I can describe it is that you have some of the major emitters, if you will. So you have Ontario and Alberta, even Saskatchewan, that are perhaps wanting to take a different approach towards carbon emissions. But if they don't meet those targets, the impact of those emissions in terms of climate change may be felt by people in the Arctic, Indigenous people, the Maritimes, who have a very long coastline. And so this is something that really does affect all of Canada. And in that context, the federal Canadian government needs to be involved.
So, Professor Newman, on this national concern question, the Supreme Court called it itself. It said that this is a little used legal doctrine. Can you give me another example of where national concern has been applied? And if you think that this was the correct time to apply it here?
Well, it has been used occasionally before. The standard leading case before this was about marine pollution, where they ended up saying that because basically pollution in one area of marine waters would affect into another area, that was something of this same sort, where you had to let the federal government regulate it because the provinces couldn't do it on their own. There are more intricate legal tests to it than that, but this is the kind of thing that they're concerned with under this doctrine. The government gambled a bit in devising a scheme that they decided they had to try to uphold under this doctrine. They could have argued a simpler taxation power case if they devised something that fit neatly within the taxation power, and instead they argued it this way.
Yes, certainly. So, Omer, certainly the federal government has very broad power to tax, and to me it looks like they chose to do this complicated scheme to avoid calling it a tax. I have some concerns about the federal government taking an approach like this because it kind of lets them have their cake and eat it too. They get the benefit they want, the money, I guess, without, or the policy outcome without the political consequences of a tax. Are you concerned they could do this in other cases?
Yeah, I think we all have to be concerned about this case and about this act. But I think we have to balance that concern with the very real threat of climate change. I think that's what ultimately swayed the majority, is that they relied very extensively on the fact that for many, many years, we have been fighting climate change in Canada. We haven't met our goals. We haven't met the promises that we've made to the international community. And if we continued along this way, we probably wouldn't. And so I think those are two very, very important and competing demands or competing concerns. And Canadians should keep an eye out to make sure that this type of power perhaps isn't continuously used in the future.
We'll continue that after this commercial break. Welcome back to Canadian Justice, where we're talking about the recent Supreme Court decision on carbon taxes. Professor Newman, this is a case that involved a very forceful defense. There were two dissenting opinions. A third judge agreed with one of the other opinions. Could you explain what the dissent said in this case?
Sure. So there's a partially dissenting opinion from Justice Cote. She's concerned about an unconstitutional delegation of decisions made under the Act and writes about that. It's a little bit different than anyone was expecting, perhaps, as argument in the case. The main dissents come from Justice Brown and Justice Rowe, and they're fully in dissent. They do write two separate dissenting opinions, so that's a lot of the judgment. And they're concerned really with this idea that the majority arrives at, that minimum national standards fit within the scope of the national concern branch that we've been talking about. Justice Brown's really forceful about his concerns about that, saying that the majority has rewritten the rules of confederation, going so far as it's striking language in a judgment. And Justice Rowe is approaching it a little bit differently, but getting at many of the same sorts of things. And a lot of concerns from those dissenting justices about I think implicitly the implications for other contexts, because they say this isn't consistent with what's been done with POG before on their reading of it.
Yeah, I mean, Justice Brown said that the majority's decision was momentous, and I think a lot of people might read it that way as well. Omar, do dissents matter, though? What impact do these dissents have in this case?
I think they matter significantly. They may not matter necessarily for the immediate outcome, but they matter from the perspective of legitimacy of our democracy, legitimacy of our courts, and legitimacy of our belief in the society functioning. So, the dissents raise some very, very important and interesting issues, and I think they're worth considering and reflecting on, and important as well, because if there is, and this is what everybody's concerned about, if there is an attempt by a federal government down the road to try to use powers in this same way, but perhaps in a situation that doesn't involve climate change, those dissents will provide very valuable insight and ammunition for parties who are actually opposing those government actions.
Yeah, certainly I can see the whole concept of a backstop being used in other areas of traditional or constitutionally delegated provincial jurisdiction, healthcare, for example. If the federal government doesn't like how the provinces are running healthcare, could they impose a backstop this way? Professor Newman, do you have any concerns about that?
Well, I think this is one of the big worries that people could have about the judgment, thinking it might have expanded federal power significantly in those areas. Now, to give credit to the majority, they would say that there are some special factors about climate change where it meets some additional requirements within the tests that they set out. But I think it's going to require a lot of analysis to see what other kinds of situations this could apply to, as the doctrine of the national concern branch now. Things like healthcare have a resemblance to this. A differently minded federal government could try to use this to disrupt provincial trade barriers in a sort of a creative way. National standards for long-term care homes, other resource issues, each of them will need to be thought about carefully in light of different factors about the test that's there.
Yeah, I can certainly see the federal government looking at this decision as an opportunity to expand some of their powers into areas that they have a lot of policy interests. I want to thank you both so much for joining me today to break down this decision, this complicated and lengthy decision for our viewers. It's been a pleasure talking to you, both of you.
Thank you.
Thanks for having us.
We've heard today about the different policy and legal reactions to the federal carbon tax and the recent Supreme Court decision upholding it as constitutional. Now that it's been upheld, it will apply to provinces without strict enough carbon taxes of their own. Whatever your view on the decision, it looks like carbon taxes are here to stay. But constitutionality is not a policy endorsement, and the debate on whether carbon taxes are the right solution to climate change rages on. Is top-down taxation on the essentials of life, like home heating and fuel, the right approach to climate change? Or should governments focus on innovation and encouraging private sector green technology? You be the judge. I'm Christine Van Geyn, and remember, a freer Canada starts with you.